Welcome back to our Mueller Report audiobook. We're up to episode 12. We're in volume 2. This is the second episode. We're in volume 2. The first episode of volume 2, we only got through 8 pages, but that was some very introductory and foundational information for the report. So we're now moving through into further through volume 2, background, legal and evidentiary principles. So there's a lot of legal speak in the next recording. Legal framework of obstruction of justice. The May 17, 2017 appointment order and the Special Counsel regulations provide this office with jurisdiction to investigate federal crimes committed in the course of and with intent to interfere with the Special Counsel's investigation, such as perjury, obstruction of justice, destruction of evidence, and intimidation of witnesses. Because of that description of our jurisdiction, we sought evidence for our obstruction of justice investigation with the elements of obstruction offences in mind. Our evidentiary analysis is similarly focused on the elements of such offences, although we do not draw conclusions on the ultimate questions that govern a prosecutorial decision under the principles of federal prosecution. Here we summarise the law interpreting the elements of potentially relevant obstruction statutes in any ordinary case. This discussion does not address the unique constitutional issues that arise in an inquiry into official acts by the President. Those issues are discussed in a later section of this report, addressing constitutional defences that the President's Counsel have raised. 3 basic elements are common to most of the relevant obstruction statutes. 1, an obstructive act. 2, a nexus between the obstructive act and an official proceeding. And 3, a corrupt intent. We describe those elements as they have been interpreted by the courts. We then discuss a more specific statute aimed at witness tampering and describe the requirements for attempted offences and endeavours to obstruct justice. Obstructive act. Obstruction of justice law reaches all corrupt conduct capable of producing an effect that prevents justice from being duly administered, regardless of the means employed. An effort to influence a proceeding can qualify as an endeavour to obstruct justice, even if the effort was subtle or circuitous, and however cleverly or with whatever cloaking of purpose it was made. The verbs obstruct or impede are broad and can refer to anything that blocks, makes difficult, or hinders. There's lots of case law references here, which I'm just not referring to, just for ease of listening. An improper motive can render an actor's conduct criminal, even when the conduct would otherwise be lawful and within the actor's authority. Relevant case law there. Any act by any party, whether lawful or unlawful, on its face may abridge 1503 if performed with a corrupt motive. Nexus to a pending or contemplated official proceeding. Obstruction of justice law generally requires a nexus or connection to an official proceeding. In section 1503, the nexus must be pending judicial or grand jury proceedings. In section 1505, the nexus can include a connection to a pending federal agency proceeding or congressional inquiry or investigation. Under both statutes, the government must demonstrate a relationship in time, causation, or logic between the obstructive act and the proceeding or inquiry to be obstructed. Section 1512C prohibits obstructive efforts aimed at official proceedings, including judicial or grand jury proceedings. For purposes of Section 1512, an official proceeding need not be pending or about to be instituted at the time of the offence. Although a proceeding need not already be in progress to trigger liability under Section 1512, a nexus to a contemplated proceeding still must be shown. United States v. Young and a number of other case law. The nexus requirement narrows the scope of obstruction statutes to ensure that individuals have fair warning of what the law proscribes. The nexus showing has subjective and objective components. As an objective matter, a defendant must act in a manner that is likely to obstruct justice, such that the statute excludes defendants who have an evil purpose but use means that would only unnaturally or improbably be successful. The endeavour must have the natural and probable effect of interfering with the due administration of justice. As a subjective matter, the actor must have contemplated a particular foreseeable proceeding. A defendant need not directly impede the proceeding. Rather, a nexus exists if discretionary actions of a third person would be required to obstruct the judicial proceeding if it was foreseeable to the defendant that the third party would act on the defendant's communication in such a way to obstruct the judicial proceeding. Reference to case law there. Corruptly. The word corruptly provides the intent element for obstruction of justice and means acting knowingly or dishonestly or with an improper motive. To act corruptly means to act with an improper purpose and to engage in conduct knowingly and dishonestly with the specific intent to subvert, impede, or obstruct the relevant proceeding. Some quotation marks omitted. As used in section 1505, the term corruptly means acting with an improper purpose, personally or by influencing another. See Arthur Anderson, case law, interpreting corruptly to mean wrongful, immoral, depraved, or evil, and holding that acting knowingly corruptly. The requisite showing is made when a person acted with an intent to obtain an improper advantage for himself or someone else, inconsistent with official duty and the rights of others. A lot of case law references there. Witness tampering. A more specific provision in section 1512 prohibits tampering with a witness. CUSC 1512 B13, making it a crime to knowingly use intimidation to corruptly persuade another person or engage in misleading conduct towards another person with the intent to influence, delay, or prevent testimony of a person in an official proceeding, or to hinder, delay, or prevent the communication to a law enforcement officer of information relating to the commission or possible commission of a federal offence. To establish corrupt persuasion, it is sufficient that the defendant asked a potential witness to lie to investigators in contemplation of a likely federal investigation into his conduct. Case law references there, 4 lines of it. The persuasion need not be coercive, intimidating, or explicit. It is sufficient to urge, induce, ask, argue, give reasons, or coach or remind witnesses by planting misleading facts. Corrupt persuasion is shown where a defendant tells a potential witness a false story as if the story were true, intending that the witness believe the story and testify to it. It also covers urging a witness to recall a fact that the witness did not know, even if the fact can actually be true. Corrupt persuasion can also be shown in certain circumstances when a person with an improper motive urges a witness not to cooperate with law enforcement. See United States versus Schott, telling secretary not to say anything to the FBI and she would not be bothered. When the charge of acting with the intent to hinder, delay, or prevent the communication of information to law enforcement under section 1512, the nexus to a preceding inquiry articulated in Aguilar, that an individual have knowledge that his actions are likely to affect the judicial proceeding, 512 US at 599, does not apply because the obstructive act is aimed at the communication of information to investigators, not at impeding an official proceeding. Acting knowingly, corruptly, requires proof that the individual was conscious of wrongdoing. Arthur Anderson 544, 705 to 706, declining to order the outer limits of this element, but indicating that an instruction was infirm where a permitted conviction, even if the defendant honestly and sincerely believed the conduct was lawful. It is an affirmative defence that the conduct consisted solely of lawful conduct, and that the defendant's sole intention was to encourage, induce, or cause the other person to testify truthfully. Attempts and endeavours. Section 1512C2 covers both substantive obstruction offences and attempts to obstruct justice. Under general principles of attempt law, a person is guilty of an attempt when he has the intent to commit a substantive offence and takes an overt act that constitutes a substantial step towards that goal. See United States versus Resendiz Ponce, The act must be substantial in that it is strongly corroborative of the defendant's criminal purpose, United States versus Pratt. While mere abstract talk does not suffice, any concrete and specific talks that corroborate the defendant's intent can constitute a substantial step, United States versus Irving. Thus, soliciting an innocent agent to engage in conduct constituting an element of the crime may qualify as a substantial step. See United States versus Lucas. The Omnibus Clause of 18 U.S.C. 1503 prohibits an endeavour to obstruct justice which sweeps more broadly than Section 1512's attempt provision. See United States v. Sampson, United States v. Leisure. It is well established that an obstruction of justice offence is complete when one corruptly endeavours to obstruct or impede the due administration of justice. The prosecution need not prove that the due administration of justice was actually obstructed or impeded. United States v. Davis. B. Investigative and evidentiary considerations. After the appointment of the Special Counsel, the office obtained evidence about the following events relating to potential issues of obstruction of justice involving the President. A. The President's January 27, 2017 dinner with former FBI Director James Comey, in which the President reportedly asked for Comey's loyalty, one day after the White House had been briefed by the Department of Justice on contacts between former National Security Advisor Michael Flynn and the Russian ambassador. B. The President's February 14, 2017 meeting with Comey, in which the President reportedly asked Comey not to pursue an investigation of Flynn. C. The President's private request to Comey to make public the fact that the President was not the subject of an FBI investigation and to lift what the President regarded as a cloud. D. The President's outreach to the Director of National Intelligence and the Directors of the National Security Agency and the Central Intelligence Agency about the FBI's Russia investigation. E. The President's stated rationales for terminating Comey on May 9, 2017, including statements that could reasonably be understood as acknowledging that the FBI's Russia investigation was a factor in Comey's termination. And F. The President's reported involvement in issuing a statement about the June 9, 2016 Trump Tower meeting between Russians and the senior Trump campaign officials that said that meeting was about adoption and omitted that the Russians had offered to provide the Trump campaign with derogatory information about Hillary Clinton. Taking into account that information and our analysis of applicable statutory and constitutional principles discussed below in Volume 2, Section 3, we determined that there was a sufficient factual and legal basis to further investigate potential obstruction of justice issues involving the President. Many of the core issues in an obstruction of justice investigation turn on an individual's actions and intent. We therefore requested the White House provide us with documentary evidence in its possession on the relevant events. We also sought and obtained the White House's concurrence in our conducting interviews of White House personnel who had relevant information. And we interviewed other witnesses who had pertinent knowledge, obtained documents on a voluntary basis when possible, and used legal process when appropriate. These investigative steps allowed us to gather a substantial amount of evidence. We also sought a voluntary interview with the President. After more than a year of discussion, the President declined to be interviewed. Further sentence is redacted. During the course of our discussions, the President did agree to answer written questions on certain Russia-related topics, and he provided us with answers. He did not similarly agree to provide written answers to questions on obstruction topics or questions on events during the transition. Ultimately, while we believed that he had the authority and legal justification to issue a grand jury subpoena, to obtain the President's testimony, we chose not to do so. We made that decision in view of the substantial delay that such an investigative step would likely produce at a late stage of our investigation. We also assessed that based on the significant body of evidence we had already obtained of the President's actions and his public and private statements describing or explaining those actions, we had sufficient evidence to understand relevant events and to make certain assessments about the President's testimony. The officer's decision-making process on this issue is described in more detail in Appendix C, in a note that precedes the President's written responses. In assessing the evidence we obtained, we relied on common principles that apply in any investigation. The issue of criminal intent is often inferred from circumstantial evidence. See United States v. Croteau. Guilty knowledge can rarely be established by direct evidence. Therefore, mens rea elements such as knowledge or intent may be proved by circumstantial evidence. United States v. Robinson. The government's case rested on circumstantial evidence, but the mens rea, is that what it is? I don't know how to say that. Elements of knowledge and intent can often be proved through circumstantial evidence and reasonable inferences drawn therefrom. The principle that intent can be inferred from circumstantial evidence is a necessity in criminal crime cases, given the right of a subject to assert his privilege against compelled self-incrimination under the Fifth Amendment and therefore decline to testify. Accordingly, determinations on intent are frequently reached without the opportunity to interview an investigatory subject. Obstruction of justice cases are consistent with this rule. See Edland 174-176, relying on significant circumstantial evidence that the defendant was conscious of her wrongdoing in an obstruction case. Because evidence of intent will almost always be circumstantial, a defendant may be found culpable where the reasonable and foreseeable consequences of her acts are the obstruction of justice. Quatrone. Circumstantial evidence that illuminates intent may include a pattern of potentially obstructive acts. Fedar evidence of a crime, wrong, or other act may be admissible to prove motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, or lack of accident. See United States v. Frankhauser, United States v. Arnold, and some other case law referred to there. Credibility judgments may also be based on objective facts and circumstantial evidence. Standard jury instructions highlight a variety of factors that are often relevant in assessing credibility. These include whether a witness had a reason not to tell the truth, whether the witness had a good memory, whether the witness had the opportunity to observe the events about which he testified, whether the witness's testimony was corroborated by other witnesses, and whether anything the witness said or wrote previously contradicts his testimony. In addition to these general factors, we took into account more specific factors in assessing the credibility of conflicting accounts of the facts. For example, contemporaneous written notes can provide strong corroborating evidence. See United States v. Nobles. The fact that a statement appeared in the contemporaneously recorded report would tend strongly to corroborate the investigator's version of the interview. Similarly, a witness's recitation of his account before he had any motive to fabricate also supports the witness's credibility. See Tome v. United States. A consistent statement that predates the motive is a square rebuttal of the charge that the testimony was contrived as a consequence of that motive. Finally, a witness's false description of an encounter can imply consciousness of wrongdoing. See Al-Adai v. Obama, noting that the well-settled principle that false exculpatory statements are evidence, often strong evidence, of guilt. We applied those settled legal principles in evaluating the factual results of our investigation. 2. Factual results of the obstruction investigation. This section of the report details the evidence we obtained. We first provide an overview of how Russia became an issue in the 2016 presidential campaign and how candidate Trump responded. We then turn to the key events that we investigated: the president's conduct concerning the FBI investigation of Michael Flynn, the president's reaction to public confirmation of the FBI's Russia investigation, events leading up to and surrounding the termination of FBI Director Comey, efforts to terminate the Special Counsel, efforts to curtail the scope of the Special Counsel's investigation, efforts to prevent disclosure of information about the June 9, 2016 Trump Tower meeting between Russians and the senior campaign officials, efforts to have the Attorney General unrecuse, and conduct towards McGahn, Cohen and other witnesses. We summarise the evidence we found and then analyse it by reference to the three statutory obstruction of justice elements: obstructive act, nexus to a proceeding and intent. We focus on elements because by regulation the Special Counsel has jurisdiction to investigate federal crimes committed in the course of and with intent to interfere with the Special Counsel's investigation, such as perjury, obstruction of justice, destruction of evidence and intimidation of witnesses. Consistent with our jurisdiction to investigate federal obstruction crimes, we gathered evidence that is relevant to the elements of those crimes and analysed them within an elements framework, while refraining from reaching ultimate conclusions about whether crimes were committed for the reasons explained above. This section also does not address legal or constitutional defences raised by counsel for the President. Those defences are analysed in Volume 2, Section 3. Okay, moving on to each event. A. The campaign's response to reports about Russian support for Trump. During the 2016 campaign, the media raised questions about a possible connection between the Trump campaign and Russia. The questions intensified after Wikileaks released politically damaging Democratic Party emails that were reported to have been hacked by Russia. Trump responded to questions about possible connections to Russia by denying any business involvement in Russia, even though the Trump Organization had pursued a business project in Russia as late as June 2016. Trump also expressed skepticism that Russia had hacked the emails at the same time as he and other campaign advisors privately sought information, redaction there, about any further planned Wikileaks releases. After the election, when questions persisted about possible links between Russia and the Trump campaign, President-elect continued to deny any connections to Russia and privately expressed concerns that efforts of Russian election interference might lead the public to question the legitimacy of his election. This section summarised and cites various news stories not for the truth of the information contained in the stories, but rather to place candidate Trump's response to those stories in context. Volume 1 of this report analyses the underlying facts of several relevant events that were reported on by the media during the campaign. As discussed in Volume 1, while investigation identified numerous links between individuals with ties to the Russian government and individuals associated with the Trump campaign, the evidence was not sufficient to charge that any member of the Trump campaign conspired or coordinated with representatives of the Russian government to interfere in the 2016 election. Press reports allege links between the Trump campaign and Russia. On June 16, 2015, Donald J. Trump declared his intent to seek nomination as the Republican candidate for president. By early 2016, he distinguished himself among Republican candidates by speaking of closer ties with Russia, saying he would get along well with Russian President Vladimir Putin, questioning whether NATO alliance was obsolete and praising Putin as a strong leader. The press reported that Russian political analysts and commentators perceived Trump as favourable to Russia. Beginning in February 2016 and continuing through the summer, the media reported that several Trump campaign advisors appeared to have ties to Russia. For example, the press reported the campaign advisor Michael Flynn was seated next to Vladimir Putin at an RT gala in Moscow in December 2015. That Flynn had appeared regularly on RT as an analyst. The press also reported that Foreign Policy Advisor Carter Page had ties to a Russian state-run gas company, and the campaign chairman Paul Manafort had done work for the Russia-backed former Ukrainian President Viktor Yanukovych. In addition, the press raised questions during the Republican National Convention about the Trump campaign's involvement in changing the Republican platform stance on giving weapons to Ukraine to fight Russian and rebel forces. The Trump campaign reacts to Wikileaks' release of hacked emails. On June 14, 2016, a cybersecurity firm that had conducted in-house analysis for the Democratic National Committee posted an announcement that Russian government hackers had infiltrated the DNC's computer and obtained access to documents. On July 22, 2016, the day before the Democratic National Convention, Wikileaks posted thousands of hacked DNC documents revealing sensitive internal deliberations. Soon thereafter, Hillary Clinton's campaign manager publicly contended that Russia had hacked the DNC emails and arranged their release in order to help candidate Trump. On July 26, 2016, the New York Times reported that US intelligence agency had told the White House they now have high confidence that the Russian government was behind the theft of emails and documents from the Democratic National Committee. Within the Trump campaign, aides reacted with enthusiasm to report of the hacks. Got a redaction there, discussed with campaign officials that WikiLeaks would release the hacked material. Some witnesses said that Trump himself discussed the possibility of upcoming releases. A redaction. Michael Cohen, then Executive Vice President of the Trump Organization, Special Counsel to Trump, recalled hearing a redacted sentence. Cohen recalled that Trump responded, "Oh, good, all right." Manafort said that shortly after WikiLeaks' July 22, 2016 release of hacked documents, he spoke to Trump, and that part is redacted. Manafort recalled that Trump responded that Manafort should redacted and keep Trump updated. Deputy Campaign Manager Rick Gates said that Manafort was getting pressure about redaction information and that Manafort instructed Gates redaction status updates on upcoming releases. About the same time, Gates was with Trump on a trip to an airport, redaction, and shortly after the call, Trump told Gates that more releases of damaging information would be coming. Redaction there were discussed within the campaign, and in the summer of 2016, the campaign was planning a communication strategy based on the possible release of Clinton emails by WikiLeaks. Trump campaign reacts to allegations that Russia was seeking to aid candidate Trump. In the days that followed WikiLeaks' July 22, 2016 release of hacked DNC emails, Trump campaign publicly rejected the suggestion that Russia was seeking to aid candidate Trump. July 26, 2016, Trump tweeted that it was crazy to suggest that Russia was dealing with Trump and, for the record, he had zero investments in Russia. In a press conference the next day, July 27, 2016, Trump characterized this whole thing with Russia as a total deflection and stated that it was far-fetched and ridiculous. Trump said that the assertion that Russia had hacked the emails was unproven and stated that it would give him no pause if Russia had Clinton's emails. Trump added, "Russia, if you're listening, I hope you're able to find the 30,000 emails that are missing. I think you will probably be rewarded mightily by our press." Trump also said that there's nothing that I can think of that I'd rather do than have Russia friendly as opposed to the way they are right now. And in response to a question about whether he would recognise Crimea as Russian territory and consider lifting sanctions, Trump replied, "We'll be looking at that. Yeah, we'll be looking." During the press conference, Trump repeated, "I have nothing to do with Russia," 5 times. He stated that the closest he came to Russia was that Russians may have purchased a home or condos from him. He said that after he held the Miss Universe pageant in Moscow in 2013, he had been interested in working with Russian companies that wanted to put a lot of money into developments in Russia, but it never worked out. He explained, "Frankly, I didn't want to do it for a couple of different reasons, but we had a major developer that wanted to develop property in Moscow and other places, but we decided not to do it." The Trump Organization, however, had been pursuing a building project in Moscow, the Trump Tower Moscow project, from approximately September 2015 through June 2016, and the candidate was regularly updated on developments, including possible trips by Michael Cohen to Moscow to promote the deal and by Trump himself to finalise it. Cohen recalled speaking with Trump after the press conference about Trump's denial of any business dealings in Russia, which Cohen regarded as untrue. Trump told Cohen that Trump Tower Moscow was not a deal yet and said, "Why mention it if it is not a deal?" According to Cohen, at around this time, in response to Trump's disavowal of connections to Russia, campaign advisors had developed a party line that Trump had no business with Russia and no connections to Russia. In addition to denying any connections with Russia, the Trump campaign reacted to reports of Russian election interference in aid of the campaign by seeking to distance itself from Russian contacts. For example, in August 2016, Foreign Policy Advisor J.D. Gordon declined an invitation to Russian Ambassador Sergei Kislyak's residence because the timing was not optimal in view of media reports about Russian interference. On August 19, 2016, Manafort was asked to resign amid media coverage scrutinising his ties to the pro-Russian political party in Ukraine and links to Russian business. And when the campaign published stories about Page's connections to Russia in September 2016, Trump campaign officials terminated Page's association with the campaign and told the press that he had played no role in the campaign. On October 7, 2016, Wikileaks released the first set of emails stolen by a Russian intelligence agency from Clinton campaign chairman John Podesta. The same day, the federal government announced that the Russian government directed the recent compromises of emails from US persons and institutions, including from US political organizations. The government statement directly linked Russian hacking to the releases on Wikileaks with the goal of interfering with the presidential election, and concluded that only Russia's senior-most officials could have authorized these activities based on their scope and sensitivity. On October 16, Podesta stated publicly that the FBI was investigating Russia's hacking and said the candidate Trump might have known in advance that the hacked emails were going to be released. Vice presidential candidate Mike Pence was asked whether the Trump campaign was in cahoots with Wikileaks in releasing damaging Clinton-related information, and responded nothing could be further from the truth. After the election, Trump continues to deny any contacts or connections with Russia or that Russia aided his election. On November 8, 2016, Trump was elected president. 2 days later, Russian officials told the press that the Russian government had maintained contacts with Trump's immediate entourage during the campaign. In response, Hope Hicks, who had been Trump campaign spokesperson, said, "We are not aware of any campaign representatives that were in touch with any foreign entities before yesterday when Mr. Trump spoke with many world leaders." Hicks gave an additional statement denying any contacts between the campaign and Russia. It never happened. There was no communication between the campaign and any foreign entity with the campaign. On December 10, 2016, the press reported that US intelligence agency had concluded that Russia interfered in last month's presidential election to boost Donald Trump's bid for the White House. Reacting to the story the next day, President-elect Trump stated, "I think it's ridiculous. I think it's just another excuse." He continued that no one really knew who was responsible for the hacking, suggesting that the intelligence community had no idea if it's Russia or China or somebody. It could be somebody sitting on a bed someplace. The president-elect also said that Democrats were putting out the story of Russian interference because they suffered one of the greatest defeats in their political history. On December 18, 2016, Podesta told the press that the election was distorted by the Russian intervention and questioned whether Trump campaign officials had been in touch with the Russians. The same day, incoming Chief of Staff Reince Priebus appeared on Fox News Sunday and declined to say whether the president-elect accepted the intelligence community's determination that Russia intervened in the election. When asked about any contact or coordination between the campaign and Russia, Priebus said, "Even this question is insane. Of course we didn't interface with the Russians." Priebus added that this whole thing is a spin job. He said, "The real question is why the Democrats are doing everything they can to delegitimize the outcome of the election." On December 29, 2016, the Obama administration announced that in response to Russian cyber operations aimed at US elections, it was imposing sanctions and other measures on several Russian individuals and entities. When first asked about the sanctions, President-elect Trump said, "I think we ought to get on with our lives." He then put out a statement that said it's time for our country to move on to bigger and better things, but indicated that he would meet with intelligence community leaders the following week for a briefing on Russian interference. The briefing occurred on January 6, 2017. Following the briefing, the intelligence community released the public version of its assessment, which concluded with high confidence that Russia had intervened in the election through a variety of means with the goal of harming Clinton's electability. The assessment further concluded with high confidence that Putin and the Russian government had developed a clear preference for Trump. Several days later, Buzzfeed published unverified allegations compiled by a former British intelligence officer, Christopher Steele, during the campaign about candidate Trump's Russia connections under the headline, "These reports allege Trump has deep ties to Russia." In a press conference the next day, the president-elect called the release an absolute disgrace, said, "I have no dealings with Russia. I have no dealings that could happen in Russia because we've stayed away. So I have no deals, I have no loans, I have no dealings. We would make deals in Russia very easily if we wanted to. I just don't want to because I think that would be a conflict." Several advisors recalled that the president-elect viewed the stories about his Russian connections, the Russia investigations and the intelligence community assessment of Russian interference as a threat to the legitimacy of his electoral victory. Hicks, for example, said that the president-elect viewed the intelligence community as his Achilles heel because even if Russia had no impact on the election, people would think Russia helped him win, taking away from what he had accomplished. Sean Spicer, the first White House communications director, recalled that the president thought the Russia story was developed to undermine the legitimacy of his election. Gates said the president viewed the Russia investigation as an attack on the legitimacy of his win, and Priebus recalled that when the intelligence assessment came out, the president-elect was concerned people would question the legitimacy of his win. And we might stop there because we move on to another chapter looking at Michael Flynn, which we can start in the next episode.